The renunciation. Well, what is a renunciation and when do you use it? Hi, I'm Darren Findling of the Probate Pro, and we're going to examine State Court Administrative Order Form PC 567. PC for Probate Court. SCAO is the short term for State Court Administrative Order. Now, this form is used in a very particular context. It's used in an informal administration when you're seeking the appointment of a personal representative by application for informal probate. That process I've covered in a separate video, and with all of these SCAO forms, you're welcome to contact my office. We'd be happy to give you one free of charge. We're going to walk our way through this form to understand when it's used and how you use it. With all of the SCAO forms, they are guided and created by various statutes or court rules. And as you can see from the hovering arrow in the bottom right corner, the two statutes here, 700.3203 and MCL 700.3310, are the statutes that give rise to this particular pleading. Now, again, through probate, as you're navigating your way through probate, we strongly urge you to be working with a skilled, competent probate practitioner to understand how you navigate through the probate process. Probate is complicated, it's non-intuitive, there are steps that you wouldn't even think are required, and it's critical to be able to be assured that you perform your responsibilities correctly. So work with a skilled, competent probate lawyer. Now, this form is used with an application for informal probate. And often people confuse the waiver and consent form, another form I've described in a video, with the renunciation form. They're different. The waiver and consent is used for other purposes. The renunciation is used in the informal context for the application for informal probate. Top left corner in the blue rectangle, you'll identify the county upon which the probate matter is proceeding. And in the top right corner, the file number. Now, often when you're filling out this form, you don't even have a case number yet, because usually you're attaching it to the application that's going to get filed. And as you can see from the name of it, it's a renunciation of a right to appointment, the nomination of a personal representative, and a waiver of that notice. Top part identifying the name of the estate. The I section is who is signing the document. So in this context, under Michigan's statute, there is a pecking order of priority for the appointment of a personal representative. So if you have either an equal or higher right to appointment of a personal representative, you would identify yourself and you're saying to the court, I have a right to serve as personal representative, either equal or higher, but I'm renouncing it. I'm giving up that right to serve in that role. So before you sign this form, really think about, do you want to give up that right? Do you trust the person upon which you're giving that right up to effectively perform their role as personal representative through this probate process? The next section are various checkboxes. It's a renunciation of that right. You have the right to nominate, so in certain circumstances, if you're identified with a high priority, you can actually give that right to another person, and you can identify who you want to give that right to. You also can say, well, I have a right to do it, but I don't want to give that right to another person. I'm simply renouncing my right to nominate another qualified person to act as the personal representative in the deceased estate. And then fourth is the waiver of the notice of the appointment. Again, an area for the signature, an area for an attorney, if there's an attorney involved that's representing you as the person that's renouncing the right to serve as personal representative. This form, pretty straightforward on how to fill it out, but it's confusing because the term renunciation is not a term that most people really understand what it means. So when they get it, they look at it very confused. But it is a renunciation of the right to serve as personal representative. It also allows for the waiver of notice and the appointment or nomination if you have that right to do so. And only under certain circumstances can a high priority personal representative nominate another person to serve and act in that place. You'll notice that in the bottom section there is a note, and this goes to what I was just saying. A person with priority is set forth in a will. So if there's a testate estate, a will, and that person is nominated as personal representative, including a person nominated by power conferred in the will, does not through the priority of the power to nominate. So often people say, well, I'm nominated in the will, I'm going to give that authority to a third party, and you can't do that under Michigan statute. So a person nominated in the will doesn't have the right to nominate another unless set forth in the testamentary document. There are other prioritizations that have to be met before you can nominate. So under that pecking order, a surviving spouse or children and so on can do that nomination, but not the person nominated in the will. At the Probate Pro, we're passionate about everything probate. If you have questions about the informal probate process, the renunciation, or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.